You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. And welcome. Our guest today is trial lawyer and surfer and just all around great guy, Dan Schaar. Dan, welcome to the show.
Thank you. I don't know. Surfer, good guy may go above the lawyer sometimes, but the surfing doesn't pay the bills, right?
Not yet.
Not yet, right?
For folks who don't know you, tell us a little bit about your practice and how you got there.
Yeah. So I am a plaintiff attorney that was a former defense attorney. I actually started my career working for the dark side, which actually got me a lot of trial experience. It also got me a lot of empathy experience and realizing that that was not the side I wanted to be on. So I've been a plaintiff attorney now. I'm almost in my 13th year. Um, so I run kind of a two-headed practice, so to speak. I run a lot of cases through my own firm, Schaar and Silva, and then I also run some cases with my partnership with Trial Lawyers for Justice, Nick Rowley and Courtney Rowley's firm. But it's all plaintiff side, catastrophic personal injury. My office itself, my team, I run a pretty selective practice. So it's not mass volume. I know every single one of my clients by their first name. I've been to all their houses and, all their pets and kids and everybody. So it's a very deep practice in regards to my connection with my clients, but I only handle a handful of cases at any given time. And yeah, I'm in Santa Cruz, California, and yeah, so that's sort of big picture for you there.
Hey, Dan, let me ask you this because we've got some defense lawyers who listen and really enjoy the podcast. They're like, man, we love the podcast. For folks who might currently be doing defense work but are thinking about making a switch over to the plaintiff side, what would you say?
I mean, do it as fast as you can. I mean, it's one of those things. I am glad that it happened when it did for me because I had only been a defense attorney for a few years, so I hadn't become embedded into the comfort, so to speak. I mean, this is the one thing as plaintiffs attorneys we know, like there's not a steady paycheck. There's not a steady flow when you work for an insurance company. It's grind, but you have a pretty consistent client. And so, for defense attorneys that want to make the move, find a good plaintiff attorney that you like and that you trust, and almost engage them in a mentorship type role to kind of figure out, because it's a big shift of having to sort of float your entire practice and not have that guarantee backup. But there's so many good plaintiff attorneys out there. You do not need to do this alone. And, as COVID has taught us, we can connect like this so easily. I think before COVID hit, the Zoom and these meetings, yeah, you did virtual stuff, but it was like the exception. Now it's like you can live in New York and have a mentor in California, or, be in Santa Cruz and have great conversations with attorneys in South Carolina. So, find somebody that you've connected with, find more than one person, and just kind of go with it. And the majority of the plaintiff's bar is very kind. And yes, like we all want to do well for ourselves and well for our clients, but there's enough people out there that need help for it to go around. So yeah, that would be the best piece of advice is connect with that plaintiff attorney that you really enjoyed, and just talk and go for it and take the plunge. Because I mean, it's the longer you're in that comfort zone, the longer that blanket stays on you of the consistent paycheck with the insurance side. I think the harder it is for you to get out.
And I'd say too, for those folks, it's like, hey, the worst thing that can happen is it doesn't go that great, and you go back and get a job at another insurance defense shop.
Yeah, exactly. But
Um,
most of the time, I've found that almost everybody that I know that really is willing to jump in with both feet, um, they're fine. The ones I've got a close buddy of mine who I won't name, but he's down in LA, and I have this conversation. I've been having this conversation with him for years. I'm like, you are too good to stay on the defense side because he does occasional plaintiff work, but his big thing is his like young family, and I got to make sure I've got the consistent stuff. I'm like, bro, let me know. I'll help you out. I will fly down to LA. I will help you out however you need. So, it's just take the plunge, both feet, do it.
Yeah, I love it, man. I love it. Dan, the main topic of the podcast today is about trial prep and how trial prep can frame for deer, opening, closing. You've done a ton of work in opening. In fact, I've got a presentation I'm giving in a couple days on kind of best practices for opening, and one of the practices, one of the styles is going to be like the Dan Schaar style opening. But let's
So
kind
you
of
gotta
rewind.
make sure you put the little copyright at the end of that,
It
right?
should. I mean, that's like, again, it's kind of giving people it's the whole purpose of this
Yeah.
podcast, right?
Oh
It's like,
yeah.
hey, here are best practices from some of the country's best in different areas. And yeah, I mean the Dan Char opening is like,
Thanks.
pretty sweet. And it helps that Pulp Fiction is my favorite movie.
Yeah. Right.
So whenever you talk about the Pulp Fiction opening, I'm immediately like, yes.
Yeah. Well, and
Um,
this is the thing I think as plaintiff attorneys, it's like you're not stealing anything. Like, it's one of the conversations that it's actually one of the reasons why my current partner, my direct partner, Eva Silva, and I left our old firm is we worked for an outfit that did not see the benefit in teaming up with other attorneys. I can remember one of the last conversations I had with my former boss of saying, hey, we should bring in this particular big name attorney. And he just straight up looked at me. He said, why would we do that and share our fee? And it was just like, because it's not about us, it's about the client. And the fact is that that person will triple the value of the case. So you're still going to make more money. But yeah, so the sharing of stuff, absolutely do it. And like for me, I am constantly evolving even my own stuff because I'll watch something Nick does, or I'll hear something, or it's like, oh my gosh, that is great. And I figure out I don't necessarily steal it completely, because remember, that's not me. Whatever Nick does or whatever you do, whatever I do, we want to make sure we're not staying specifically within the script of that person, but take it and mold it to your own. And I think that's what's important with it is take what other people have done, meld it all together.
yeah, I mean, I really like the idea of, when you get to the portion of the client story in an opening or otherwise, but mainly in an opening where, if you're wanting to talk about what their life was like, and you go to the morning of, right? The morning of the event, and here's what life looked like. And one of the things that I've started to like doing is going from that morning to the next morning. And then you get to the next morning, and the next morning is like very, very different. And then boom, image of whatever it was. Ladies and gentlemen, this is what happened in between, where you've built in psychologically, oh, that's clearly what caused all of this. But rather than go morning of event next day, I like going morning of, talk about it, next day, talk about it, and then in between, kind of that reveal.
Yeah.
um, just like you said, taking something that, some other people are talking about, like, all right, how can I tweak this? Something that kind of fits, something I find interesting, something I like talking about. But going back to trial prep, share with us kind of, again, trial prep, and how it creates the frames for these different aspects of trial.
Yeah, and it's we use that phrase trial prep. I mean, it's almost like, I know I think Jerry used to say these things, and it's like, you start prepping for trial at the intake. And I mean, and that's kind of where it is it's like if we use that big overarching umbrella of trial prep, I mean, it's really it's litigation prep, but it is trial prep because as the saying goes, it's like you can settle any case that you're ready to try, but it's very, very difficult to try a case that you've been preparing to settle. And so, yeah, I mean, the prep for us starts at intake. And, for me, sometimes I just take notes. Sometimes I have a little sheet that actually Jacob Norman, my partner, came up with a few months ago that's so great that it basically has these boxes that I utilize, or these pieces that I like to utilize in my openings and closings and stuff like that. And we'll sometimes use those as my template for note taking during the intake process and during depositions and stuff like that. So it's like a working document of every single piece of information that I'm learning throughout the process. Where does that plug into the eventual trial frame? And so, the prep is ongoing. The biggest mistake that I've ever made, it's like before we jumped on, we talked about that case I jumped into 12 days before. which does happen sometimes. We have to do that, but my preference is to start it at day one and just slowly plug every single piece of evidence in, good, bad, ugly. It has to go somewhere, because if I don't know the bad and the ugly, I don't know what I need to reframe or eliminate when I eventually have to try the case. So, yeah, I mean, it's a long way of answering the question, but we start at the beginning. Every piece of information we have, okay, that's a good fact, plug that in here. Oh, this is a bad fact, probably need to throw that into the defense reframe part, this, that, or the other. And also, by doing that initially, and I've got my sort of my trial framework, that also can help with some of the discovery planning that we have to do. And in California we have expansive discovery. I know in South Carolina I've got a case there right now where it's you do have a fair amount of discovery that you can do. But I mean, the only way that you're really going to know about the specific and the unique things that you're going to need to ask about in discovery, you got to take notes. You got to start the trial prep as early as possible.
Yeah. Thank you. And that's so true. I mean, you articulate that to a T. So Dan, for again the work that we're doing and the foundation, let's talk about openings, and then again we can talk about close, we can talk about rebuttal. But share with the audience just your approach to openings, kind of where you are with it today in the fall of 25.
So it's funny because my preference is I always start with closings. But from the order of things, if we're thinking from a timeline standpoint, a linear timeline, I try to get more stuff plugged into the closing before the opening. Doesn't always work out that way, but they also work in tandem. You gotta remember, it's like, the stuff that I'm going to put into the closing, it probably has to be touched on an opening. If it's not touched on an opening, it's got to be during the trial, because if it's not during the trial, it's not coming in closing. So I mean, my approach with this, and I kind of have my set pieces of what I'm looking for. Um, if I had to pick one part of the opening where I really do try to start, it's actually in what I call the hook, like the theme, so to speak. And that's kind of what it's an evolving monster, but it's sort of, the most famous, if the glove doesn't fit, you must have quit, those types of things. Obviously, that was a closing hook, but because obviously Johnny didn't know that Darden was going to do what he did, but these things happen. But that's where I kind of start, because it's like, all right, this is sort of my frame up here, and this is sort of the empowerment hook, and I'm trying to build my evidentiary story to kind of help that hook make sense. But that's sort of is always the starting point. But I guess if in regards to the big chunk standpoint, the most important part of my opening is the human story, is finding out the who he or she was, my client, before this whole process happened. So that's where the most work comes in, to not only the trial work but to the opening itself, is you know who is this person, and why should these 6, 8, 12 perfect strangers from our community give a crap about this person. So, yeah, the human story also starts at the intake. It also starts at the beginning. And this is where you're putting your work in and going to your client's home. You're speaking with your client's friends, their coworkers, their bosses, their ex-spouses, which candidly, if you're not utilizing exes as your discovery plan, you're missing a huge, I mean, it's some of the best witnesses that I've ever seen have been people that are no longer in a relationship with the client, either because or not because of the incident itself. I mean, I had a guy just the other day who, it's a medical malpractice case, and he's like, the best witness you will have is my ex-wife, because she loves me now. She didn't love me before. But it's like, these are the things that you kind of look into, that human story. You need to be spending a tremendous amount of time. If you're not going to your client's home at least once and diving into their world, you're missing out big time.
Dan, when you're spending time with clients, with friends, with family members at their homes, other spots, are there specific questions? Are there specific aspects of this person or their story that you found kind of apply more generally? I mean, in other words, are there specific things you do to really bring out those human stories that you're going to want to be able to share in opening?
You know, I wish I could say yes, but no. It's because everybody's so unique. I mean, it's sort of like it, the agenda that you come into with gathering the human story should be the same agenda that you have when you go into voir dire, and that is no agenda. I think this is something that Nick teaches a lot, and I've really sort of adapted it. Is the biggest problem we run into in voir dire is when we try to go in with an agenda to get these people switched and flipped and this that, because you just lose credibility with that. And so I've kind of felt like, excuse me, with the human story when I go, are there things that I want to find out about? Of course, absolutely. But going in and there being like a magic question or anything like that, I usually find that when I sit down, the reason why I like to do the home is, you can learn a tremendous amount about people when you see where they live. Do they have photos on their walls? Do they, you know, are there dirty dishes, this, that, or the other? And so oftentimes the only agenda I have is making sure when I get to the house, like I find something that I can create a topic of conversation on. And a genuine topic. Like it's, the one thing that I think I have a great, I'm very fortunate is I've traveled a lot. I've lived a lot of different places. I've had a lot of different jobs. I've made a lot of mistakes. And so I have a pretty broad, um, spectrum of conversation. And so there's a lot. It's very rare that I can show up to a person's house and not find at least something to start talking about. And that's where it just goes. And that's where I kind of find where it leads. One tip that I give people is I always run Otter AI on my phone when I'm talking to clients, and I just put it over there and I just let it free flow because then I can engage. I don't have to take notes. And honestly, some of the stuff that you get, you're just like, oh man, I'm so glad I was running that reporting. And it's protected, it's attorney client. So it never gets produced.
So it's so funny. My question for you was going to be, hey Dan, what are you doing to best capture these incredible these magic moments, right? Like there are these magic moments that happen when you're with clients, you're at their house, and making sure those things get captured. And we use, I mean, Otter is the one that we
Yeah.
use on the phone, and we'll take pictures when we're at the house to create kind
Yes.
of those cues or tripwires.
Yeah. Yeah, and ask for,
Thing.
and yeah, just like we have a wrongful death case, like the photos from the memorial, they're not sitting around people's houses, but you wind up, we took a picture of Jacob and I represent a young girl whose mom died in front of her basically, and one of the most powerful images I think is the note, the thank you note that the daughter wrote, and made sure that everybody at the memorial got a copy of it. So like that's a powerful image that isn't up on a wall anywhere. It's the grandma saying, oh, you probably want to see this. So yeah, definitely take pictures of stuff and look deeper than the photos that are up on the walls and that are up on the mantles.
Thank you. Thank you. The human story, again, a centerpiece or a major block of the opening. And you were talking earlier about, again, you like to plug in, if we're going to look at it chronologically, you're plugging in parts in the closing throughout. What are you what's kind of the basis for you decision making wise of like, all right, I'm going to plug that, or I think that's got a spot in closing, I think that's got a spot in opening. Like what kind of, how does it pass the test or kind of clear the hurdle, or where you say, ooh, yeah, that man, that's going?
Usually, not always. I'd be lying to you if I said I focus group every single trial. We bat about 95% on that. Every once in a while, one sneaks through where you're just like, well, we're flying blind. But usually, the focus groups are where the test sort of helps, and we try our best not to rely on just a single data point with focus groups. We utilize both small neighborhood focus groups where we, get 8 to 10 people on a Zoom call, pay them $100 for a couple hours. And then we also use the big data focus group. We like to use John Campbell. Um, and that'll help too. But yeah, usually it's either the focus group or it passes my wife's test. If she thinks that it makes sense, because she's my greatest defense juror. My wife is like a phenomenal defense juror, and I always say if I can convince her, we're good. So I'll run stuff, and that I think the people that are in your lives, it doesn't have to be your spouse, it doesn't have to be even sometimes I'll run stuff by my kids. They're little kids, but sometimes they have unique thoughts on things, and it's like you can pick up things from anybody, but yeah, the thing that usually will help me make the decision on whether something should stay or go is when somebody else who isn't neck deep in the case says, yeah, that hits, versus my own thought process on it, because there's a lot of times where you're so deep in it you can't see the fact that a particular piece of evidence is just not hitting.
Yeah, and Dan, so let me ask you this. Again, having cases from the start and being able to work it the way you want to work it, being able to build it the way you would like it built. What are you looking for in deposition to help create a more compelling trial presentation?
In regards to like the client stuff, opposing witnesses, just generally speaking.
I guess in my mind, that's a great question. When I was thinking of it, I thought more about, your defendant and your defendant witnesses, but I guess also for client depositions.
Yeah, so if we start with client depositions, just because that tends to be a little bit more consistent, is I try to have, well, my clients always, I'm meticulous in my preparation. I mean, it's it's always so wild because, as a little aside, I am doing a pro bono case for a friend of mine. He's a defendant, and he's going to be deposed in a couple of weeks, and the defense attorney has confirmed that I'll be available for an hour before the deposition for his prep. And I'm like, dude, it blows me away. So the meticulous aspects of I've got a depo actually on the day before Halloween. Today was the first of many prep sessions that I have with a client that we go through it. So meticulous preparation, because I want my clients to be able to give their best testimony in deposition. Like I prepare them as if they are going to be deposed, they're going to be testifying in trial like this. So, the key things is I don't shy away from making sure that they let out as much of their human story as possible. I make sure that's actually a part that they're well prepared for. Because I actually think that's the most important part. I mean, the medical is what it is. Yeah, that's a key component. That's a component of it, but that's only going to be a small part. So I'm really looking for my clients to make sure they can expand on their human story in depo, even if I have a defense attorney who isn't going to ask those questions, which the majority of them don't. They spend a small amount, like they're so focused on the medical and the wage loss, this, that, or the other. So I'm spending a tremendous amount of time trying to get that aspect out of the client's depo. As it relates to the defense, this sort of depends upon the position that the defense is going to be taking. If I've got just a rock solid slam dunk, clear liability case, obviously I'd love to have that admitted before the depo, but sometimes I can't. It's a lot of times it's making sure I can understand the human aspect of the defendant as well. I think early on in my career, once I became a plaintiff attorney, I was taught this mindset of every deposition you take of an adverse witness you have to have your swords out, and you just basically have to destroy them. And I have found that um, that is not the way I do it now. The way I do it now is I want to make sure I understand, okay, what is the human side of this person? Because if they are going to testify in trial, I got to know who they are. I really got to know who they are, and what they're going to wind up saying, because oh my gosh, do I not have the better side? Am I losing the human side? So a lot of times in depots, yes, I'm focusing on the facts, but I'm also focusing on the human side of it. Perfect example, yesterday I had an Uber driver depot. I spent 95% just basically hammering on the crap contract that they have when they're an Uber driver. Because I wanted to see what kind of guy he was. And he was a really, really nice guy. And so the whole depot was just basically hammering the Uber side of things rather than him as the driver. So it's always going to be um, case by case. But if there was a fallback default, it's always what is this person as a human, and what do I need to learn about them so I'm not blindsided at trial.
Yeah, what are you doing? Are y'all doing role playing in office or ahead of time to get ready for the human aspects of the defendant testimony?
I don't do a lot of that. I am a trial lawyer, college grad. So I'm very, I'm trained in the things regarding, psychodrama and those types of things. But I have found that more often than not, that's not the way I go with it. And the main reason for that, candidly, is a lot of times it's just speculation, and we're making crap up to figure out, okay, is this person actually is is this really who they are going to be? And so I thankfully have done enough of this that I'm like, all right, I'm just gonna have to go in and wing it a little bit. And then once they sort of fall into that particular personality aspect, then I'm like, oh, okay, this is the way we're gonna go. This guy's gonna be a jerk, and I can kind of put on that hat and be a little bit more aggressive versus okay, this person is very kind, and I can match kindness with kindness. It takes a lot for me to put on the jerk hat, even if the the witness is a jerk. So yeah.
So we talked about portions of the human story. We talked about depositions. Dan, let's talk specifically about case framing. One of my favorite episodes to date was years ago. We did with a fellow named Chris Hamilton in Dallas, who was one of the lawyers who got a multi-billion-dollar verdict against Charter when one of their techs murdered a
Mm.
customer. But Chris did a great job talking about framing. It's one of my favorite topics. You've done a tremendous job on it throughout your career. So tell us some about when it comes to framing for opening, closing, rebuttal, just some of the things that you do.
Yeah, so I mean, it's starting off with, as we kind of touched on earlier, knowing these particular pieces, so to speak. It's like for me when I do my framing, it's like everything sort of it falls in its place. And if it doesn't have a place, then it doesn't get brought out. So that's another thing we talked about with how do I know what sticks is number one, if it's in a box or a piece, a puzzle piece, so to speak, and a focus group supports it, then it stays. But if I've got a piece of information, and candidly, I can't think of anything that I can't plug in somewhere, but let's say that there was that situation, then it's not coming in and opening, and it may come in trial. But I always have to question myself. It's like, okay, if there's a piece of information that I've got, and I can't figure out what piece it's supposed to go in, I am missing something because it's got to go somewhere. And so we plug all this. So for me, I'm piecing everything together. If I'm doing the opening, we talked about there's always that hook that's in there, and then the human story. But I think one of the other most important pieces of the frame, and this kind of goes back to what we talked about before with the the defendant's deposition, is especially in a contested liability case, you got to figure out what either this individual defendant or his or her boss or the principal did. What were the choices that they made? And one of the things that I think is becomes a very important phrase when we are dealing with what we mostly deal with, which is negligence, is you fall into the negligence phraseology. That's the defense phraseology. Like, I hate, oh, negligence. No, every single thing, even if it is negligent, is still a choice. Okay. When somebody runs a red light, okay, oh, it's just an accident. No, that person made a conscious decision to not pay attention. That is a choice. And so, what I oftentimes find with the framing that becomes a very important part of the framing, which goes back to the deposition stuff, is you've got to know those choices. You've got to know what's going on. And sometimes it can be really difficult. In California, we've got defense attorneys, I'm sure you've got those in South Carolina, that they don't want you to get any good information about what was going on that morning at the company meeting or this, that, or the other. But you got to dig. You got to find out, okay, where does this start? Because one of the key pieces of the framing itself and why one of the driving forces, in my opinion, of larger verdicts is the more bad choices you've got that you can pin to this defendant, the more piss off you're going to have. Now, sometimes it's hard. Sometimes it just purely is somebody ran a red light. There's nothing else to that. But sometimes, like you deal with stuff like with the Monsanto cases or police shooting cases or, any of these cases where, you're dealing with months, years, decades of bad choices that you've got to get in. And that's another key part that gets put into the framing aspect.
And do you dig into, I know you do, but like what would you teach and share in terms of like identifying those choices, those bad choices, those dangerous choices, and then kind of one layer below that, the motivations, the reasons, the why that that was really driving the defendant's decision making.
Yeah, I mean, this is where, for us, most of my practice is in California state court. So we don't call them 30B6s. We call them PMKs or PMQs, person most qualified, person most knowledgeable. But, utilizing your 30B6 for many, many purposes. I mean, this is the great thing about this is, and sometimes I think people that don't engage in the practice that where they're looking at 30B6 witnesses don't realize this. You're not limited. Like you can take as many 30B6 witnesses as you want. And so, start with your topics, find out these topics and dig as deep as you can, but your first 30B6 witness may be giving you all the choices, but they might not be giving you the why. And so, you've got to then go to that next part. You've got to go to that next part. Now, the deeper you go, do you run into the risk of getting shut off because it's like, well, hey, this is just a negligence case. You're getting into the punitive stuff. But at the same time, at least in all courts that I practice in, judges is still, as long as there's a potential that it's going to lead to the discovery of admissible evidence, it's a prime topic. And obviously you got to be, don't ask the questions of, well, how much profit did you make off this decision when you don't have any allegations of punity? Obviously, but you can get crafty with it. You can kind of find out it. And the most powerful question that you can ever ask in a deposition is why. Just ask. It's like, okay, I did X, Y, why? Okay, why did you do that? Why did you do that? Okay. And defense attorneys hate it because they always object to vague. It's like, really? Why is vague? Okay. You don't and sometimes a 30B6 witness who can't understand the why question, that's a great clip in trial. Okay. This is the person that they're gonna tell you. I mean, this person can't even answer these particular questions. So sometimes the 30B6 will go far and you'll get some great stuff. Sometimes you get other stuff that they just look stupid. And then there's other times where they don't show up and you just, all right, fine. They couldn't even present somebody. So there's a lot of different ways you can utilize it. But yeah, I mean, it's utilize your discovery tools because you're not limited on how many of these corporate witnesses, these PMK witnesses that you're allowed to take. Because yeah, you want to dig as deep as you can to find the source of why this choice was actually made, and stop calling it an accident. Try to avoid using the word negligence. It's always about a choice, because it's accidents happen. Accidents are forgivable, but choices, it's that language that jurors, they start latching onto that, and it can really lead to driving up the value of verdicts. And then of course your verdicts go up, your settlements go up.
You got it. Dan, on the frame, one additional kind of piece and something that we talked about with Chris Hamilton on that episode I referenced, but anticipating what the defense frame is going to be
Mhm.
therefore creating a plaintiff frame that every time the defense tries to argue within their frame, they're actually probably pouring a little bit more fuel on the fire. Can you speak to like creating not just a frame, but a winning frame that the defense, by arguing against it, may again be increasing the value or increasing the likely verdict amount?
Yeah, I mean, a lot of times, for me, what I do, I'm kind of looking at some of my notes on certain things that there's always the what I refer to in my opening is the defense reframe. It's usually towards the end of my openings, and the reason why is because if I do it at the beginning of the opening, it almost comes across as whiny, oh, well, they're going to say this, they're going to say this. Whereas if I do it at the end, the defense doesn't have as much time. If I'm sort of ripping their case apart in the last 3 to 5 minutes of my opening, they're going to stand up next and the first thing they got to do is they got to make a decision. They either stick with their textbook opening that they're going to do that they were probably writing while I was doing my opening anyway, or they immediately have to become the whiners and try to explain why our reframe is wrong. So yes, in every case, I always make sure that I have what I believe is going to be the defense three, the big three, so to speak. I'm a big fan of the rule of three. Do they sometimes have more than that? Yeah, maybe they do. Do they sometimes have less? Well, they might. But you have to always know, and this is where the preparation comes in. This is where all the prep work goes because you've got to know. You've got to have a pretty good idea by the time you go to trial of what the defense is really going to try to make this case about. And those are the big three. And so, yes, the frame up with that is you pick, for example, like let's just use a real simple one: degenerative changes. Okay, I think every trial lawyer has to try at least one pre-existing condition case. You just have to. I mean, and honestly, I think they're great cases because as long as you know how to try them. But like degenerative changes is a great one, and most of the stuff I do is not original content. A lot of it I take from Nick, a lot of it I've taken from Keith Mitnick. But you take the degeneration. Folks, one of the things we're going to talk about, you're going to hear a lot is this phrase degeneration. Okay, degenerative changes. It sounds like this horrible word. And usually what I do is I always have a little joke. I just say, I've got really bad news for you. For the last 45 minutes, you have degenerated. You have been degenerating, listening to me talk, because this is what the human body does. It ages. And the word that we call is degenerative changes. You're going to hear them talk about it a lot. But just remember, degeneration just means aging. We all age, and that has nothing to do with why, this, that, or the other. So if you take it, so then you own that phrase. They're going to say degeneration. What's another big one? Low impact, low impact. All these different things. So take it, give it a little bit of I don't know, a funny twist to it, because then, yes, every time, if you've done it right, every time they bring this up during trial, the jurors are like, well, yeah, but that's just aging. I mean, and sometimes it can become offensive. Like if they hit it really, really hard, it's like, oh, so because I'm aging, like I'm not worthwhile either. So you try to find those phrases that you can spin around. They're going to utilize them, and it can really have an impact on the jurors individually because it almost seems like they're being attacked as well. And that's at the end of the opening, right before I usually talk about what the tell, what the number is going to be, and that's always at the end of the opening for my framing.
Yeah, excellent. Um, as far as coming back to that frame and in closing, or ways that throughout the trial proceeding that some things have gone as anticipated, some things have not gone as you anticipated. When you're
Okay.
coming back to those frames and working through it in closing, how do you like to either reiterate or adapt the frame for purposes of your close?
So it kind of follows, I don't want to say it follows the same path, but the hope is everything has sort of come in. And so it matches up. The largest difference, at least the way that I like to do it, compare it between the openings and the closings, is the opening is always based upon particular puzzle pieces that go together, while the closing frame has these puzzle pieces. The guiding map is always our verdict form or the jury charge, whatever, however you call it in your particular jurisdiction. So that is running as the roadmap of my closing, so to speak. So like, yeah, I mean, in closings, we're still talking about, we're reminding them of the story itself, but we're reminding them of the story in regards to the damages questions. And so that's how it gets plugged in there. I also am a big fan, and this is something that I know I picked up from Nick years ago. Big fan of utilizing constitutional arguments, Declaration of Independence arguments, life, liberty, pursuit of happiness. Really, because I've found that not only, I mean, I'm very fortunate that a lot of times I practice in your progressive or liberal jurisdictions, but every single county I practice in has at least 12 very conservative individuals. And so I know there's always a chance I could have a very, you hate saying red, but a very conservative jury, so to speak. So I always have to assume that I'm going to have the broad spectrum, regardless of the county I'm practicing in, where I'm going to have people that are all over the place. And so I find that the life, liberty, pursuit of happiness really bodes well to your, I hate saying conservative, but people that tend to be right of center. You can really, they really take pride in the Constitution and the Declaration of Independence. And so it works really well because it gets them that feeling. Um,
And Dan, I'd
yeah,
say for the folks who are listening,
yeah,
also look at your state constitution. Like
yeah,
South Carolina has some great stuff in
yeah,
our state constitution,
yep,
where it's like for folks, taking pride nationally, for folks who are very proud of their state, wonderful gems that in a lot of ways mirror or track the U.S. Constitution or Declaration of Independence.
yeah. And it's in spite of, we don't need to turn political on this one, but in spite of, where anybody falls, like, and this is the one thing too that goes back to the agenda with voir dire is, if you have an agenda and you're convinced, and I'll just use it, you think, oh my gosh, I don't want MAGA, I don't want a Trump voter on my jury for whatever reason it might be. Why? I mean, let's think about this. It's just like, okay, is there aspects about this case that have anything to do with what that person's political viewpoints are? They still are, they're still someone's son or daughter, and find out who they are. Do those things because I have found that the some of the best jurors I ever had are the worst on paper jurors. One of the best jurors I ever had was um, she was a HR director at a big oil company, and her husband was the head of claims at Alliance Insurance. Okay, you tell me, is that a juror? As a plaintiff? No, we kept her. She was our foreperson, and she gave us every penny. She was phenomenal. And on paper, I mean, I can still remember getting back to my hotel room after we did the jury questionnaires, and my paralegal, who is phenomenal, the best paralegal ever. She hands me the stack, and she's graded them, and this juror questionnaire had the biggest F red dot I have ever seen. And on paper she was terrible. Talked to her, she was great. And so go into these things, it's like everybody's got a beating heart, and everybody has. You have to find out, because I've had liberal jurors who are terrible. They're just angry, they're terrible. So you find out who they are. You don't have your agenda, but that's why, if we go back to the framing and the stuff with the independence, Declaration of Independence, those types of things, everyone can relate to that regardless of their political affiliation, because at our core, we're all Americans, and we live in this country that was founded upon those principles. And regardless of where you may see yourself now, if you're doing it right and you're really tapping into their emotional and their heart feelings, you're gonna get them. You got them.
And
Um,
we did a recent episode with Joe Freed, a buddy of mine, Chris Finney, who's a
yep.
fantastic trial lawyer in St. Louis, and it was about things Chris had learned from Joe and applied in the case where he got a great verdict out in St. Louis about these universal values, the
Mhm.
universality of human values and what really matters to all of us. And you go anywhere in the country, and pretty much everyone's going to say, in one form or fashion, their family is important to them, their health is important to them, a relationship with a higher power, God in their understanding, whatever it may be, is important to them. Their independence, their pursuit of happiness. These are the things that matter.
Right.
Not want, wanting to feel like they're adding to the world and not burdening the world. Um, what a concept.
Yeah, I mean, it's this is the is, and we're eh, we are a lot more alike than our politicians would like us to believe. And I think that's the thing, and I think you nailed it. The universal truths that almost every person, and yeah, are there outliers? Of course, but usually the outliers you can find them pretty quick, and so for the most part you're getting these individuals that maybe but yeah, like they have got those beliefs.
I never really thought about it till this exact moment, but it's like we hold these truths to be self-evident. It's like, look, we don't even have to say this shit,
Right.
but because it's so evident. But let's go ahead and tell you about life, liberty, and pursuit of happiness.
Yeah.
Dan, when we get to rebuttal, what are some of the things that you're liking to do in rebuttal that you found most effective?
You know, brutal honesty, rebuttal is always my weak spot. And I know it shouldn't be. I wish I was better at it, but rebuttal is it's one where the only thing that I am consistent with in my rebuttal is I like to do the book of life rebuttal. I don't know if you were at TLU, not this last year, but a year ago. I kind of touched on this, and this is something that I've sort of not developed on my own. I got the idea from Bob Simon, my buddy out in LA at Simon Law Group, great guy.
I
And
think I
so
think I think Bob will be the episode right before this one. He's so great.
Bob's wonderful. Like
I
he and I've
mean, what a
been.
guy.
It's so funny because
Yeah.
I don't normally have a beard. I'm growing my beard out for Halloween, but he and I used to be the Beard Brothers, and we've known each other for a long time. And he's just a great guy. And he and I years ago were talking about the Book of Life stuff, and I came up with this thing. It's the only thing that I ever include in rebuttal. I find it to be a very strong empowerment of talking about how the Book of Life works through 4 chapters, and we kind of go through that process because it really helps people understand the it helps the jurors understand the true empowerment that they have. But beyond that, with for me for rebuttal, is I oftentimes make sure that I'm keeping notes during the closing of hey, all right, where are the things that I really have to hit on this, and oftentimes because defense closings are almost always the same. It's greedy plaintiff, not really hurt, biased experts, et cetera, et cetera, et cetera. But yeah, the key things that I find with rebuttal is I make sure that I'm prepared to understand the out of context facts that the defense is going to take. So the cherry picking phrase. So we kind of point out it's like, now you sort of know why we're here, why it's taken us how many years or decades to get here. We talk about cherry picking, cherry picking, cherry picking. Mitnick has a great line of, outside the courtroom, it's things have to be kept in context. Taking things out of context is unfair outside the courtroom. In the courtroom, it's especially important that things are put into context because people's livelihoods are on the line. They cherry pick here, they cherry pick. Sort of the little piss off things is hit on the cherry picking aspects. And then if they've scored a couple points on a couple things, I throw that in there. But yeah, I find that the book of life empowerment is pretty powerful because it gets people really to realize it's like, hey, listen, each one of us has our own book of life. Each one of us is supposed to be the author of the chapters in our book of life. And here, that's not what happened. The defendant took that away from our client on such and such a date. And, the verdict now gives that power back, so there's a lot of empowerment with that. So I tend to be pretty boring with the rebuttals. I know there's a lot of attorneys that's the exact opposite. I know, like my good buddy Brian Ward, he's phenomenal with rebuttals. And I can still remember the case we tried together years ago where he stood up and basically just blew through a great rebuttal, and the judge was telling him to sit down, and Brian's like, I'm not done yet. And you did a great job. So yeah, for me, I tend to just be hit on the cherry picking. hit on the cherry picking aspect, and then hit on the empowerment of Book of Life, and that's kind of where I go with it. So my rebuttals are almost always pre-written, aside from a few, maybe a couple things that were put out. And I think part of it was just I and maybe I'm wrong, but my mindset on my rebuttal is I don't want to make it seem like I'm giving credit to what they just heard. And so I keep it short, sweet, and again, bring the focus back to the empowerment of the jury.
And Dan, I think it's a great place because ultimately where we've gotten to is empowering the jury for when they go in that deliberation room to return the right verdict for the right reasons, which is a phrase that's always resonated with me. Uh, let's kind of end on what you're truly empowering your jury to do. Again, you've talked about juror empowerment. Um, when you say juror empowerment, what is it you're ultimately hoping for and kind of speaking toward?
Yeah, and empowerment is something that, I'm glad we're kind of closing on this, because empowerment is something that I throw out through many aspects of the opening. I start off with the empowerment. I talk about the jurors that, you're the only jury that ever gets to decide this case. And so you start with that, and you build it, and then you're building it through the opening. And then, yeah, with the empowerment at the end, it's just making them realize, and making them truly understand. It's like, uh, all of us rely on the jury system, even if we are not the litigants that are there. And, reminding the jurors of our system exists for a reason. Not that we want to ever use it, but it's there when we need it. And it just so happens that today she needs it, or he needs it. Um, and sometimes I will push a little bit, even though sometimes people say it's golden rule. I don't think it's golden rule. Just so you know, and the hope is that if there ever is a time that you need it, that 12 citizens just like you answer the call for you like you have for her. And so, you start that, and then with the empowerment, towards the empowerment is just making them realize, it's like, hey, I can't do this. She can't do it. I point to the judge. Usually I say, and not even his honor has the power to be able to conclude this story. Only you have that. So it's sort of like, I think all of us want a feeling of belonging. And in this situation, the empowerment is letting them know, hey, your decision is gonna stick with her or his life for the rest of their lives, and so you belong. And I have found that more often than not that it works pretty well. Does it work all the time? No. I mean, have I lost cases? Yes. You can't try cases and not lose. So sometimes it doesn't work. But yeah, I think that feeling of community, that feeling of belonging, is kind of what we're trying to empower, and making them realize that, hey, your decision here actually does make a difference.
Yeah, and it so parallels, the empowerment, the purpose, the autonomy. I mean, so many of the things that you're creating and giving to the jurors or reminding them that they possess are the same things that were wrongfully taken from your client.
Yeah.
Um,
Yeah.
Dan, man, thank you, thank
Of
you,
course.
thank you, thank you.
Yeah.
For folks who want to get in touch with you, what is the best way to do it?
Probably through my TL4J email. So it's just my name, Dan, at TL, the number 4J.com. Yeah, I mean, send me an email. I love chatting with people, and even though my practice is primarily based in California, I handle cases all over the country. I got a case with our buddy Jason, out in South Carolina. So I've got a couple Texas cases. So yeah, and one of the things too I've always tell people, it's like I do this not just to represent the plaintiffs, but to represent the plaintiffs bar. I mean, it's like we're all here fighting the good fight. So yeah, reach out. You got any questions at all? Be happy. And if you're out Santa Cruz, I'll tell you where all the good surf spots are. And
Such
so yeah.
yeah, a good plug. We were talking before we hit record. If you haven't been to Santa Cruz, it's easy. Just go. It's such a great town. It's like, I mean, if I were gonna like draw up like, hey, Santa Cruz, would be like, man, here's Dan Schaar, here's a super cool piece of art above him on this like
Yeah.
really cool exposed brick. Like it's
Yeah.
this is a great representation of like Santa Cruz and what an amazing place it is. Special
Yeah.
place.
We're real fortunate, yeah. And if you're a movie buff, there's been some great movies filmed here, and The Lost Boys was filmed here. The scenes from Endor in Star Wars, all the redwood trees, that's all Santa Cruz Mountains. Yeah, I mean, there's a lot of really unique history here, and it's if you're into the tech stuff, you can always be over in San Jose. You got Monterey. I mean, it's we're really fortunate to be here. So yeah.
Special place.
Yeah.
All right, my friend. For everyone who's listening or watching, thank y'all so much. Our guest today has been Dan Schaar. This has been Best Practices with Kenny Berger, and we'll do it again soon. Take care.